The phrase that I hear so often is, the employee doesn't have a contract, or this person doesn't have a contract and therefore he's not an employee. This is in actual fact not true. The question is a non-written agreement a valid agreement? And the answer is yes. A contract doesn't need to be in writing to be valid. So taking you back, you want to have a written employment agreement to avoid pitfalls. The pitfalls is you want to have more clarity, you want to stay out of the CCMA, and when the Department of Labour comes to do an inspection, that is the first thing they would ask is, do you have an agreement? And there's certain clauses that needs to be in an agreement. I'm going to tell you what these clauses are and why they are important. So firstly, the employer and the employee's names, so you know the parties to the contract. Second of all, the employment, the job title, and what duties and responsibilities this person would be responsible for, to avoid any confusion. The place of or the place of work is very important, to know where they should report for duty every day. Another important clause is the hours of work, so the employee knows what is expected of them, how many hours they should work, and if it is an employee earning below the threshold, they would be entitled to overtime pay, and therefore they would know at what stage they are entitled to overtime pay. Then your leave days, how many leave they are entitled to. This is now sick leave, maternity leave, your normal leave. It's important to set those out in your employment contract. Then there's no confusion for the employee. They know exactly what, how many days they have for each of those. And then the notice period or the termination clause is also important, because the employee needs to know, if I resign, how many days I need to work notice. This is normally set out if you've worked for less than 3 months, it's only 1 week, 6 months, it's 2 weeks, and more than a year, you would need to work 1 month's notice pay. Another important clause is the commencement date of the contract. This is important for you as well as the employee to know when the contract commenced, and especially when it comes to termination, where you maybe need to retrench someone or they resign. You need to know the commencement date, because that would determine the amount payable, or how that amount is calculated when it comes to retrenchment or the notice period that the employee needs to work. So just to touch on that notice period, say for instance, employee resigns with immediate effect, and the employee has been working for the company for a year, or there's a notice period that the employee is required to work. The moment when the employee resigns with immediate effect, that employee is no longer entitled to that notice pay. But should the employee resign and the employer tells the employee not to work the notice period, the employer should still pay the employee for that period that he had to work, because then it is the employer's choice not to let the employee work. So this is yet another reason why it is important to have these clauses in your employment contract. When the employee does not work the required notice period that's expected of him, you can have that clause already in your contract that says, if you don't work your notice period, you will not get paid for that period. And that's important to note in your contract.